you confirm that you're still under oath, say I do.
I do.
Thank you, Chair, for the indulgence. Just one or two matters of housekeeping. The first one would relate to the document which was provided to us, I think it was day before yesterday, and then copied, day before yesterday it was provided, and yesterday it was copied after the witness dealt with it. You would recall it is the letter from the Public Prosecutor's Office of Bochum relating to the preliminary criminal investigation of your client Jens Gessen. This document, or copies thereof, have been distributed, and I saw that when the witness was referring to this document earlier this morning, it was just a loose document which does not form part of any bundle. We have decided for purposes of the record that it forms, it becomes RMY 151. RMY 151, and it will follow on the documents that are in file 7. It will be numbered just after the last page there. This will become the first, and then there is the document which had been inadvertently not included in the bundle. That was RMY 100, and that will go into file 5. Now, that will come in just after file RMY 99, which is at page number 1911. Now, it would then become, if numbered correctly, and in order not to upset the numbering that already is in the papers, it will be 1911, starting at A, following, it is a 35-page document. It will be 1911A and end at 1911II.
Thank you. Can we continue with the evidence?
That is the document that the witness had referred to at the end of his paragraph 477 of his statement. You have the document before you, Dr. M.
Yes, I do. Sorry, the two relevant documents. You're talking about the contractor security plan or the other one?
Yes, I'm referring to the contractor security plan, RMY 100.
Yes, I do.
And the relevant portion of that document dealing with the theme that we are dealing with here is, do you have a copy of the document in front of you?
I do, yes. But if you just remember that I actually wanted to deal with the I think 102 before 100.
Have the commissioners found the relevant document?
Just that it's differently marked on our document. It's differently numbered, but we've got it.
RMY 102, Commissioner Musa, it shouldn't be differently numbered. It's supposed to be the same document. At page 1917, file 6.
Sorry, I thought you were talking about RMY 100.
Yes, may continue, Dr.
If you've only got one or so page, but it'll be the Annexure A, Part 6. Annexure A is the building specification for the MECO A200 SAN, and Part 6 is with reference to the RPMS simulator.
The document the witness is referring to appears at pages 1922 and 1923 for the record. Yes, you may proceed, Dr. Young. I believe this document already has been entered into the record.
I'll accept that. Okay. Anyway, as I've said, it says Part 6, RPMS simulator. Now, importantly, and for the record, this is a document that I received from the DOD under PIA, a complete, or ostensibly a complete, the umbrella agreement. As I've said before, but I need to mention again in this context, the judgment and the order gave no direction or even mentioned a redaction or severance. I've been asking for this particular part of the umbrella agreement for several years now, both in response to the PIA procedure as well in the context of this own Commission of Inquiry, specific document that I've referred to, and it's never been provided to me. Be that as it may, I have to deal with what I have, and also what I don't have. What I don't have is the pages clearly following Part 6, because the very next page that I've got is Annexure B, without anything in between. These are obviously header pages. But nevertheless, we're talking about a 3rd of December 1999 umbrella agreement. So that comes after the selection by in terms of the letter of the Chief of Arms Corps, and it comes later than the other items of evidence. So certainly if there is a selection by the Arms Corps on behalf of the DoD, in fact at the directive of the Project Control Board of the project officer to provide this information, one would expect that the GFC to whom this letter was directed would have included the IMS simulator, the one that we had quoted. Nevertheless, that's all that this umbrella agreement has to say in this regard. I'll pause there for an instant while I get to, and we all get to, the next relevant document, which is RMY 100.
As pointed out earlier, Commissioners, RMY 100 is in file 5. The page numbers there are 1911, starting at A. I've just been advised, Chair, that the documents, it does appear, they are erroneously marked as 1910. It ought to be 1911, following on RMY 99. You may proceed, Doctor.
Okay, just to address the authenticity of the document, I only really want to address one line, but if we look at the very first page, unfortunately I see the document is has a security classification of confidential, which I suppose being a security plan would make sense to some at least, but nevertheless it's also stamped with the stamp of ADS registry being the entity who handled documents, and it was them who provided, ADS who provided this document to us, because of course it's in the context of the entire Corvette and the combat suites, and it does mention the IPMS simulator as well. But as importantly, although this document status is indicated on page 1 as draft, it has a date of issue of the 20th of January 2001, which is quite a long time after the umbrella agreement was signed, and even longer after the DoD and Arms Corps had made their selections. Nevertheless, taking myself to my bookmark under the IPMS simulator, which is on my page 10 of 35, I'll maybe pause there to make sure that everybody's in the right place.
That would be 1911K for the record. Now that would correspond to typed page 10 of the document.
That's correct. The page numbers are on the bottom right-hand side, page 10 of 35.
Yes. What point do you wish to make with regard to that page?
The table above there, item 438, is the IPMS simulator, and indicating the subcontractor as being the following three parties: Siemens, FRG being Germany and South Africa, combination of those, and C squared R squared RSA. I just want to point out that here is another documentary indication that the IMS simulator was part of the baseline, and it just had to be if it was in a document of this nature at this particular point in time.
And you state that it having become apparent that C squared I squared was deselected in respect of the IPMS simulator, something was mentioned, I think at the time, by Admiral Kammerman, before the JIT, where he gave evidence. Would you like to deal with that with your DTI 0487?
Probably appropriate at this point to say that the point I'm going to come to next is what he said in respect of the IMS simulator at the Public Protector's hearings. But I think it's probably appropriate that this issue was also addressed by him in these in his evidence before this commission. And I've got another theme, as we know from my witness statement, as my responses to his evidence. And I think it would be appropriate that I dealt with it now while the issue is fresh in at least our minds and in front of me here. Of course, there are two ways I could deal with it here, under the theme of the IPMS simulator, or I could deal with it there under the theme of my response to his evidence. But with the imperative of going forward as fast as possible, my own view is that we would deal with it quicker, dealing with it now. So I'll wait for a directive from my evidence leader and the chair in that respect.
I think we're dealing with that subject matter already. We can just, for purposes of completeness, just deal with it now.
I think that's a good idea. I do have the correct witness statement paragraph numbers here right in front of me. It will mean paging forward a little bit, but at least I've got the correct hard-coded numbers. So hopefully we can get there and get back again. I don't have to go there because I've actually copied them here. But nevertheless, with that direction, I will deal with, first if I may say, maybe by way of just introduction to this sub-theme, where I say in my paragraph 478, it was clear that C-squared R-squared system was deselected and also at a very late stage. And why I say that is it's not an interpretation. It is that my point is that we had been selected, and clearly we weren't at the end, so it must mean we were deselected, and it certainly happened in several years later. But nevertheless, what then Captain, I think it was actually then Admiral Coleman stated at the public protector hearings, is that he says under oath, but I'm now...
Perhaps just to enable us to find the page, that transcript is what we had dealt with earlier. It is RMY 95. It starts at page 1765 of the bundle of documents in file 5. Which page of that transcript do you want to refer to?
Quotations here, one indicating the page of the transcript as 1215, and the second one as page 1217.
The typed page 1215 corresponds with our numbering 1818. If you could refer to the line where that quotation comes from. If you go to line 10 of that transcript, perhaps you'll find it.
Okay, I'm just going to... Okay, I don't have a bookmark there, so it'll be quicker unless I'm directed to do so, just to use my witness statement, if that's okay.
Yes, your witness statement is taken as from line 10 of our page 1818 and the typed transcript page 1215. If you look at line 10, it starts with the sentence but I am now going to come to the fact that he alludes that the IPMS simulator was selected by the state.
That's correct. Unfortunately, I'll read it again from my own evidence, but I am now going to come to the fact that he alludes that the IPMS was selected by the state. Then he goes on to say that that letter, I'm not sure exactly which letter, I suppose we could work that out, but that's not so important, however, was in no way a selection by the state. I'll pause there. Did I hear your...
Now, that passage appears at the typed page 1217 of the transcript, corresponding with our page 1820. It starts at line 11.
Okay. It says, that letter, however, was in no way a selection by the state or a prescription on the main contractor. It was merely a suggestion that the main contractor consider C2R2 as a potential supplier. I think what I do need to say is that what I've just traversed before clearly shows that there was indeed a selection by the state.
In your theme of dealing with the IPMS simulator, in terms of the evidence that was presented before the Commission, as you proposed to round this off for purposes of completeness, would you like to refer to paragraphs in your statement where you deal with this?
Yes. I'm referring here to just a direct copy from the points in my own witness statement starting at 717. Should I pause there just to make sure everybody can get to 717?
Paragraph 717 appears at page 185 of your statement.
Okay, and as I said, I'm referring to his evidence to this commission, and I have that in front of me. I'm not sure how we deal with it, but at least it is my understanding that transcripts of previous witnesses are on the record, so I haven't discovered that document.
What is it that you want to say regarding the evidence of Admiral Kammerman before the Commission?
It's not much. As I've said in my 717, is that I dispute the allegation that we lost the RPMS simulator on the grounds of performance, price, and timescales. That's something that Admiral Kammerman testified on page, which is recorded in page 6181 of the transcript of his evidence. As I've said before, my paragraph 718, it was 3 years later in 2001 when we were asked for another quote, and then we applied about a 30% increase, which was quite normal and justifiable for that period of time. The issue of one of my directors, Alistair Knight, being overseas on a courtesy visit to Bloemfontein, attending a meeting. I don't need to ventilate in that great detail, but he did attend that meeting, and he was bulldozed into attending a meeting for which he wasn't prepared, I didn't know about, and it was on this basis there was some indication that we hadn't done. Well, it's recorded that he was forced to concede that we had not done any work on these type of simulators, which is we had not. However, there was no concession that there was deficient design, is what Admiral Carman's alluded to in his evidence, and certainly his own evidence. It says, which I traversed, I think, just before tea, that we indeed had been working on the RPMS not the RPMS simulator, but the RPMS, and that's why we can see that we hadn't worked on these simulators, but we'd been working on the technology of integrated platform management systems, and of course the relevant software. So, whatever reasons were used there were actually either not untrue or certainly not relevant. As I've said in my paragraph 720, however, we've been working on RPMS technology, software and consoles for several years, and even been selected by Arms Corps to lead the industry group on the RPMS technology. Hence, we were actually ideally placed for this a relatively simple, non-mission critical thing like an RPMS simulator. My paragraph 722 So the allegation that we lost because of deficient design, higher price, and late delivery is news to us. It was never communicated to us at the time by anybody. The proposed late delivery was based on the fact we could not deliver when the contract was not placed. And as I've said before, despite us being selected in end of June 99, we were only supplied with the first Blom and Voss requirement specification, I think it was 2001. So it's difficult how a conclusion can be made that our delivery was late. Of course, not only did that requirement specification come late, but of course, what was contained in it was also a factor. It was, there would have been some divergence before what we had quoted and what was required. So that would have led to both timescale implications and, of course, cost implications. Of course, I also found it surprising, and if I might say ingenious, for Carmen to say that that's C²R², could not place the risk in the hands of a 20-man company when C²R² had been led to believe to develop this. Okay, sorry, I've actually copied one paragraph too many here, so that applies to the IMS. I apologize for that. But if I may turn to, just to complete the point, to what was actually said in the recordal of the evidence at these hearings. I'll pause for a moment there.
Could you just provide us with the page number of the transcript you're referring to?
Yes, it's page 6180, and it starts at line 15, which includes the word RPMS simulator.
Yes, you can proceed.
Simulator, and he says he leaves it, that's he being me, leaves it complete out of his allegations now. And of course it's quite significant because that allegation and the subsequent debunking of it in public would have otherwise led to the conclusion, anybody reading these allegations, that there's a distinct hostility between him and the GFC as well, and that's another chapter completely. But in fact, we organized him, we introduced him to the German Frigate Consortium as a candidate for the RPMS simulator. But however, it was entirely in their hands to select or not select him. I think I can stop there. That has to be untrue because it clearly was not in their hands. The GFC's price was too high or it wasn't accepted, and based on what I introduced the subject to on the Navy or the DOD's specific instigation, they, first of all, they did indeed introduce us and the whole reason of technology transfer, technology retention, but clearly it was not left in their hands. The selection was made by Arms Corps. The next point is the top of page 6181. I've talked about that a little bit before, but he carries on. He says, and he lost on the grounds of performance, price, and timescales, all the three. Now, that just cannot possibly correct whether it was price. Sure, there was a 30% increase in price prevailing in those very inflationary times in this, over a 3-year period, and a change of technical baseline. A 30% price increase over that period was not, and it was fully justified, was fully transparent in terms of number of man-hours and man-hour rate increases, etc. Performance, I'm not quite sure what performance, it can't possibly have been contractual performance because the contract hadn't been issued, so we hadn't started yet. If it was the performance that we were offering, that has to be in terms of a baseline of a contract, not a contract, a specification. As we can see, the GFC changed, or reissued its contract. Our quotation was based on a statement of work and a concept description, as we described before. Certainly nothing had changed. And timescales, I think it's basically alluded to. I'm not going to try and analyze the details of that right now, or certainly not at all, unless I get asked to. But I think the relevant timescales were for the delivery of the first frigate in, it was initially around about 2003. Eventually happened in 2005 for another reason, but certainly if we were only beginning to finalize the contract technical baselines 2001, and we'd quoted 3 years to do it, or whatever we did, of course we have all that information, but it would be unfair to say that we failed, we lost on the grounds of timescales, because first of all it's never been told, okay, you lost on the timescale, so it's an unreasonable conclusion to draw for the purposes of these hearings.
Just an administrative issue, Dr. Young. Our transcript of Admiral Kammerman's evidence starts at page 6241. Are you able to explain how your numbering is not the same as ours?
And thank you for giving me the opportunity of doing so. Okay, the only way in which I was initially able to come into possession of the transcripts was by means of the famous Commission website, and I downloaded that version. But as I have said before in these commissions, quite a number of the printouts of those transcripts, including my own, as far as I know, I was actually looking at Erich Esterhazy's ones, and my very own ones are actually more or less useless for my purpose because they have spaces in between the alphanumeric characters, so you can't do a search. So I sent an email, it's on the record, to Advocate Mdumbi, who I see is here, and I think I even have that particular folder open in front of me. I see you want me to...
If you could refer
Advocate
us to the
Sibego,
number.
probably to try and expedite me. Let's leave all these administrative problems that Dr. Young alleges to have had. Let's get on with the evidence.
I don't want to have the last word, but he sent me a Word version which I printed to PDF, and it prints out those numbers itself. There certainly are some serious numbering problems in the entire recordal of all the transcripts as well.
Yes, I'm sure we will find the right pages. Is that all you wanted to say with regard to the IPMS simulator?
No, I think I've come to the end of my point under the IPMS simulator.
That would now bring us to the issue of the revolving door allegation that you deal with at paragraph 483 of your statement, and it does touch on the document you started to refer to at RMY 102 just a short while back. Could you like to take us through the point that you're developing there at 483 and 484 of your statement?
Yes, I think it was incumbent upon me in terms of at least my view of the regularity in terms of the umbrella agreement in the contract in which I was involved, and to bring it to the attention of the Commission from slightly different perspectives which have been ventilated before, which is what I will address. I think it's common cause that Admiral Carman resigned from the Navy as its project director and joined the successor in title of a company in the German frigate consortium, which was a member of the European South African consortium that was party to the, or at least its members were party to signing the umbrella agreement. The umbrella agreement has an interesting heading called remedies in the case of bribes. I'm not saying that this involves a bribe. All I'm saying is that it falls in the same heading, which may or may not be contractually applicable. But nevertheless, it's just the facts which I want to present. As I've said, it seems as though he resigned from the Navy in July 2006. I think it's important to point out for the record something which I probably had read, but the German investigating report, I think, actually said that he joined TKMS in January 2006. I stand to be corrected if I'm wrong, but if I'm not wrong, then of course it has some relevance. In any case, TKMS is an amalgamation of at least some of the companies within the GFC and the GSC, and in my view, it seems to be a fairly, I've used the term stark, so I suppose I shouldn't leave it out now, a stark example of the practice of the revolving door, and that is what, in my view, is specifically prohibited in terms of the Corvette Umbrella Agreement without the written approval, as it says, of the Chief of the South African National Defence Force. And maybe I need to say, I think it also carries to say, or his deputy. Anyway, it is on the record that no such approval was given, certainly not by the Chief of the SANDF, nor by the Deputy Chief of the SANDF, who I think does exist, certainly in terms of title. I'm not sure exactly when one was appointed, but nevertheless, I have referred to the Umbrella Agreement, and I think maybe if I may just read out what I've said here without actually going to it. I do have it in front of me, but it's quite a lengthy document, and I might take a little bit of time finding it. So I'll just pause there for an instant.
What document are you looking for?
Paragraph 484, which has got a reference to the Umbrella Agreement, which we opened up just now in respect of the IPMS simulator. But
That was our RMY 102, which is at page 1921. It is your reference 0568.
Okay, thank you. You've now given me time to click on my bookmark in this 384-page document. I have the entire document in front of me, other than the missing pieces. But anyway, my page 54, paragraph 19, which is, where do they have? Page 52 is the page number in the bottom middle of the document.
You mentioned in page 485 that in his evidence before the commission, he mentioned that he did not need that permission.
No, I'm not quite saying that. Maybe that was a view that could be interpreted, but what I want to traverse is that what I think his evidence is that his permission was signed by the Chief of the Navy. That is one point, and I don't think that it's a reasonable, certainly inference to say that the Chief of the Navy is the Chief of the SANDF's deputy, unless the Chief of the SANDF actually delegates, deputizes for them. Of course, his evidence is that automatically the Chief of the Navy is his deputy, automatically in respect of all flag officers. I'm just stating that. I'm not allowed to make interpretations or conclusions, so I'm just going to state that as unboldly as I may for the moment.
Now, there is evidence before this commission, I believe it was from former Minister Lekota, to say that the permission that was granted to Admiral Kammerman was a valid permission, and that he could despite the terms of the agreement that you have referred to, he could take up the position that you refer to. Do you have any comment there, if any, at all?
The only comment I want to make is that I didn't make these or give this evidence either lightly or boldly or without doing the subsequent the necessary research. I will state for the record, I certainly did not ask the parliamentary question, and neither did I precipitate it at all. It's just something of which I became aware. But anyway, I just do find it interesting that a witness to this commission, certainly when he was a minister and a member of parliament, his at least documentary evidence at that time was not aware of the chief of the SAND if giving that written permission. Be that as it may, I have to be quite honest, I haven't traversed Minister Lakota's evidence in great detail for my purposes now, but I certainly looked for it, and I cannot remember it being traversed in either great or certainly not sufficient detail for my purposes. But I think we have skipped over something important, so I just want to go a little bit before, so I can close this particular point appropriately.
And that is?
Yes, we hadn't actually come to the relevant part of the umbrella agreement, and if I may do so, because I have actually pointed out where that is now. I'm just reading from my own witness statement. I did have the document in front of me at the relevant place, which I have now lost, but I have now found again.
Is that the paragraph 19.2 and 19.2.1 of the document we referred to at page 1921?
That's correct. The heading of that section starts on the first page, but I wanted to go on to 19.2, which is on the next page.
What page would you like to go to?
Sorry. It is page 53 in your in the document.
Yes, that's our page 1921 that I referred to earlier. That's where you will find paragraph 19.2 and 19.2.1.
That's exactly correct, which I'm now going to read out from my witness statement because it's a bit easier to read. Anyway, it says, the seller and each of its members shall not for a period of 8 years from the effective date employ any employee or former employee of the South African National Defence Force or Armed Corps who is or was in any way involved with the agreement without the written consent of the Chief of the South African National Defence Force or the Managing Director of Arms Corps respectively, or their deputies. That's where
Now, having regard to what you have just read from your statement, how do you then relate what you say in paragraph 485 of your statement to the terms of that agreement?
Okay, maybe I just need to pause to actually go to the precursor of that, and that is that it's under the remedies in case of bribes. It says if the seller or any of its members or representatives in relation to negotiating, entering into, or execution of the agreement has carrying on and okay, maybe I'm repeating myself, or was in any way involved with the agreement. Okay, those are the important points.
Can I direct your attention to what's set out in paragraph 19.3 of the document you're reading?
Yes, thank you. Would you like me to read it? Not
Just consider it and perhaps then reflect on the statement you wanted to make regarding the contents of 19.2, 19.2.1, and what is set out in your statement at paragraph 485.
Yes, it's fairly simple. It just says any employee who is or was in any way involved with the agreement. I think that's the precursor to the point that I wanted to make, and that is in the evidence, at my point 485, in evidence before the Commission, Carmerman testified as follows: I did not need that permission, of course, because I am not party to the supply terms. What he says certainly at my page 6073 of the transcript of his evidence. So I just wanted to put that point in context.
Yeah, in what respect, yes?
What he's saying is that he had he was not bound, was not regulated, his conduct was not regulated by the terms of the umbrella agreement, because, as he said, I was not party to the supply terms. But clearly, if one just looks at the written record, he tenders his CV, which I think is, I think it's the first annexure of his witness statement, and I have that as my RMY 103.
That is at page 1924 of the bundle of documents.
That's correct, and I'm looking at the second page of 2 pages, just above the point which says later career 2000 to 2014.
Yes, what about that?
What he says here is in 1998, I led the execution of Project Citron and Project Maulstick RFO phase, leading to the evaluation process for the military value components for the selection of the preferred suppliers of patrol corvette and maritime helicopters. In late 1998, I authored the Patrol Corvette Combat Suite User Requirement Specification, URS, and in 1999, I co-led the technical negotiation for the Patrol Corvette contractual baseline, which formed the technical basis of the supply contract for the Patrol Corvettes. I wanted to emphasize technical negotiations with the technical basis and the supply contract. The supply terms and the supply contract have to be either the same thing or, to all intents and purposes, the same thing, just as the technical basis of the umbrella agreement is what I think he particularly means to refer. There's the technical terms of the umbrella agreement are the supply terms.
So the point you make exactly is summarized in the last sentence of your paragraph 4487, where you say he was intimately involved in all matters, including scope, supply, price, and the selection of subcontractors to the GFC, which ought to have disqualified him from taking up that employment.
Yes, maybe to put in my words, is I would say what I've just addressed in front of us, as well as my evidence for the last, maybe going on about 6 days, shows his involvement, not just drawing up the supply terms and the technical terms, but being deeply involved in all of the negotiations with the GFC in particular, Blom and Foss, supply terms, changing the supply terms, every single aspect you can think of involving the supply terms baseline, he was involved, and yet he says, I did not need that permission, of course, as an individual, of course, because I'm not party to this. Now, it cannot, no, I suppose I can't give an interpretation of what a party means.
So with regard to the consent, in terms of which evidence has been placed before the Commission that he was given to take up on this employment, you have nothing to say in order to gainsay that. I indicated earlier on that there is evidence before the Commission that Admiral Kammerman was given consent by the DOD to take on the employment with his new employers. Do you have anything, any comment to that?
Yes. I think maybe your term DOD is probably strictly speaking incorrect, because the permission was given by the Chief of the Navy, who works for the SANDF, which is a different division of the Ministry of Defence. So that's one point. I think it might be correct that he got permission from the Chief of the Navy, but my contention is the Chief of the Navy is neither the Chief of the SANDF nor his deputy in the normal, or at least in my own view of an interpretation of his deputy.
And you can't take it any further than that?
No.
Anything else you want to deal with regarding the revolving door, or you want to proceed to allegations of corruption relating to conventional submarines?
So we can come to that next theme now.
And the conventional submarines is another aspect of the SDPs that you had some involvement in, albeit a small one.
That's correct. I'm not a complete outsider. I certainly was a insider in a, as I concede, a relatively minor way.
Now you start dealing with the allegations of corruption relating to submarines as from paragraph 488 of your statement. Do you have it in front of you?
Yes. Of course, I have to build up to, if I make even a heading, I suppose, unlike contracts, where headings might not necessarily form part of here my heading is on the record as allegations of corruption involving the conventional submarines. So I need to put this into a context, which I'm trying to do in those few paragraphs. But I think it is relevant to say that I was a member of the SA Subclub, which means the South African Submarine Cluster. That's more of a nickname for it, and that was involved in all aspects of the submarine, not just the combat suite part of it, the combat management system part of it. And so certainly at those stage I had fairly good knowledge of what was happening at the time. And I think indeed this is fairly well what's the right word? The JRT reports basically also show that certainly I can say is that the GSC was certainly not a prime contender at all phases of the acquisition process. I don't even think from the beginning. In fact, my own view was, in fact, I certainly didn't formulate my own view of my own, because I wasn't at that level, but the GSC submarine was effectively coming forth through much of that acquisition process until pretty close to the announcement by Cabinet in, I think it was the 18th of November 98. As I've said, it's either last or second last. And lo and behold, literally a few days before, as I say, it moved into first position. So there clearly has to be some reason for that movement. Whether that movement is bona fide or not, it's certainly interesting and certainly not a waste of time to consider, certainly in the light of the evidence which I will present. And I mainly presented the German investigating reports, the first one in particular, and as we know from the chairman's own statement, hopefully that is a bona fide document, certainly one that I didn't manufacture myself. And that also records as clear as daylight that the German investigating authorities seized documents with regard to a member of the German submarine consortium, particular Ferrostal, at their head offices in Essen in Germany, which recorded their documentary records of the payment of bribes. I remember an amount of $19 million, I think, and then there were two amounts. Well, I think that there were two different amounts, although I think they seem to be the same value in euros, something like 6,603 million euros. I think that they were different amounts. But certainly it would seem that. I haven't done the same arithmetic analysis as I've done for the frigate corvette selection, as I went through in a little detail a couple of days ago, but I think it certainly would be a valuable exercise. I can remember looking at it, and I think my interpretation is at that time is there's something looks fishy here, but I can't say that right now. But what I can say is if anything comes further of these this evidence and these investigations, it's something worth looking to, because it's the devil is in the detail, and the scores and the value systems are that detail. Again, what I do know, in fact, yes, what I do know is something that I will hopefully have time to address. It is a on-the-record document. I'll state it for the record right now, from a transcript of an interview under oath from the project officer, Captain Andy Reid. And unfortunately, it was only provided to me by the Commission during the last work session with my interview leaders. That's the Thursday and the Friday of, I think it's the week before last now. And seeing it wasn't on the Corvette deal, I didn't even address it until, I think, the weekend. But I do have that document, and when I get a chance of doing so, I think that there is fairly graphic evidence of something, let's say, abnormal regarding the acquisition process, to put it as relevantly as I need to for these particular the evidence I wish to give right now. But anyway, without belaboring the detail, there certainly is something extremely interesting regarding the evaluation of the scores involving the price. One particular aspect that is ventilated in some of those documents that I only got 3 weeks ago involves the integrated logistics support component of its particular price, and it would seem that the low pricing, unreasonably low pricing for that, actually ends up in giving the German submarine consortium a very high score in terms of a military value. I think that suffices for the moment. Indeed, I refer my paragraph 493. It's also relevant in this regard. It's the evidence of Dave Erasmus, Senior Manager of the Logistics Division of Arms Corps. He was so concerned about this aspect of the evaluation and award of the GSC, he actually wrote a risk report on the matter, as well withdrew his involvement as a member of the team. I can say, having then I knew about that, but looking at the documents that I received, There's certainly reference to that. Unfortunately, there isn't a copy of the risk report or even its date, but one can contextualize it in terms of the relevance and the date in respect of Captain Reed's evidence. And it would also seem that there was also a document, another similar report by another member of Arms Corps called Antonio Don, who also withdrew his involvement from the submarine acquisition process.
What is the source of the information that you have supplied at paragraph 493 of your statement?
Yes, it is the transcript of the interview under oath with the JRT way back in middle 2001 with the project officer Captain AJC Reed, Captain Andy Reed.
You haven't made any reference to that document in your statement, is that correct?
No, I haven't. I said that is something I'd like to come to if I can, but this is something that was only provided to me the week just before the weekend, prior to the finalisation of my witness statement.
How much time will it take you to find that document?
Probably take me about 2 minutes.
We will probably can try to do that during the lunch adjournment. Perhaps we can skip that part and deal with the other matters that we can deal with on the basis of documentation. And we will, during the lunch adjournment, try and print and make copies of that document.
Thank you for that opportunity.
Right. In paragraph 494 of your statement, you make reference to HDW. Who is HDW?
Sorry, could you just my 494, is that correct?
Right.
Yes, I have to risk my German pronunciation. Anyway, Havalts Deutsche Werken, I think is as close as my English tongue can take me, is a member of the German Submarine Consortium as well as the German Frigate Consortium. They actually built a couple of the submarines and 2 of the frigates, as far as I remember. Nothing particular in this theme turns on that, but it's at least an introduction of the German Submarine Consortium, the member of which is Ferrostar, which is the one that I wish to address next.
Right, you can continue to do that.
Possibly why maybe it's slightly out of place here, but I had it in, is that HDW built some of the frigates, some of the submarines, is a member of both GSC and the GFC, and they are all part of ThyssenKrupp Marine Systems. And my point is they're all part of this group, and in the context of the theme of the revolving door, with Admiral Common having joined TKMS, it's effectively TKMS in this context at least is a successor of both Blom and Voss and of HDW. That's possibly the reason why I wrote that, but nevertheless it's relevant in both contexts.
You deal with the investigation of the German prosecuting authority at 497.
Yes, I wasn't a member of the prosecuting authority or the German raiding teams, so unfortunately I have to use the evidence which firstly is described at some length in the relevant sections at least of the raids on Ferrostal and the records that they seized there in Essen regarding the payments of the bribes. Well, no, so, yes, I think they refer to them as bribes. But let's say I'm working from memory now of the amounts of $19 million and the 6.6 million euros twice. They also referred to this in the context of Tony Georgiadis, who's probably the conduit of these funds. And as I've said before, Tony Georgiadis was the prime mover of the German Strategic Alliance, which was actually acting for both the German Submarine Consortium and the German Frigate Consortium in respect of at least their very first responses to the RFI phase of the strategic defense packages.
So your evidence in this regard is largely dependent on these investigation reports and the information that you picked up from them.
Yes, as I've also said, I was in contact with various people in Germany, a range of people, and I also want to emphasize that these are not members of the German official German investigating people, German prosecutors, a range of people, and somebody told me telephonically. So obviously I had to hear that with my own physical ears, but I will state for the record that I was told not long after these raids were done that Ferristal paid even larger bribes for GSC to win the South African submarine deal than Thyssen paid for the GFC to win the South African corvette deal.
Just hold on, Dr. Young. Who told you that Ferristal paid even much higher bribes? Who told you that?
I'm not prepared to divulge his name. He is somebody who lives and works in Germany. I think I'm saying that on the basis that for whistleblowers and for the press, sources are both sensitive as well as basically the law. Now I'm interpreting the law, but I'm making this basis on the advice I've received. Legal advice I've received is that whistleblowers are not obliged to divulge their sources.
And then why would he tell you and not the authorities in this country? Why did he pick on you and tell you that other people paid bribes?
You see, if I tell you that, then it might give you an indication. Okay, I think I can tell you without giving a direct indication who the individual is, but it's somebody, let's put it this way, with very close to, with at least very close knowledge of both the investigation and the yield of results that the search and seizure had. So it was somebody who, I know maybe I get accused of double or triple hearsay, so but be that as it may, this is a commission of inquiry. This is my best evidence. But I think I knew this a long time before I received the German investigating reports, and in fact that certainly corroborated everything I'd heard way back not long. Well, the German reports I got in 2000, late 2010, and I knew this not long after the raids in 2006, and that person was extremely knowledgeable about what had happened. Without belaboring the point, not in any untoward way, I suppose the word knowledgeable is close enough.
Dr. Young, you gave a very long explanation without answering my question. Let me leave it. I'm sure I'm not going to get any answer from you. Advocate Sebeka.
I think the question, Chairman's question, Dr. Young, was why does the person come and tell you and not make that same report to the official investigating authorities?
See, now I'm getting onto the treacherous ground of rhetoric and argue, not legal argument, but being argumentative. But the simple question is, I'm going to put the question as, okay, how do we know two things? How do we know he didn't? Okay, because it was telephonic. And secondly, how do we know that he didn't know this from the investigators themselves?
Yeah, perhaps let's leave it there and go to your next paragraph 499, which also is an extraction of some passages of the German report that you dealt extensively with yesterday, the day before yesterday. Is there anything specifically that you want to deal with there regarding the...
We've not only have we traversed it, we've also got a ruling, and I also think even without the ruling that what is on the record is sufficient for these purposes.
That takes us to paragraph 500 of your statement, where you deal with the various meetings of the SASU Club and the ADS regarding the allegations of corruption in respect of the submarine.
Sorry. Before you answer, Dr. Young, Advocate Sibek, what is the document referred underneath that quotation? Where do we find it? Or are you not referring to it?
I beg your pardon, Commissioner Musin, Chairman. The quotation on paragraph 499 appears at RMY 52. It starts at page 1086 and goes up to the next page, 1087. Yes, you're about to start the discussion regarding or relating to the various meetings of the SASU Club.
Yes, I think this point is more in respect of the submarine in general, not necessarily so much in respect of corruption, although, as a point of reminder, the German investigating report does state that Chippy Sheikh requested a similar agreement in respect of the submarine as well. So there certainly is a linkage there. But this particular point, at least the detail of it, relates more to a conflict of interest, which is more of an misconduct or an irregularity at the very least, rather than straight down. Well, it might be corruption, but it may not be bribery in terms of the payment of a bribe amount. But anyway, the point I wanted to make regards my involvement in the SA Subclub and my knowledge of Chippy Sheikh's involvement there, of the submarine combat suite, and his direct involvement in there after his recusal, not involving only the corvette combat suite, but the submarine combat suite as well.
Now, in your discussion of the meetings of the SASU Club and the involvement of Chippy Sheikh at these meetings, you make reference to 3 documents which are minutes of the SASU Club, The first one is 1998-06-26. The second one is 1998-08-19. And the third one is 1998-07-02, or it's 20, I'm not quite certain. They are, for purposes of the record, our RMY 104. RMY 104 is at 1928 of our file 6. RMY 105 starts at 1932, and RMY 106 starts at 1937. Are there any specific document or references that you want to make in respect of these minutes in support of your contention, perhaps as an introduction to the conflict of interest and an indication of some participation by Sheikh in issues relating to the contractor for the submarine combat suite?
Yes. I'm looking at the second last item of the minutes on the fourth page of 4. It's the last page of the first set of minutes.
What page did you say you're looking at?
It's page 4 of 4.
That would be our 1931, it seems. Is that the document that has future planning?
That's correct, yes.
Yes. What about that future planning?
What it says here, the chairman informed the meeting that Atlantis Consulting Pty Limited had been requested to attend meeting with ADS on the 30th of June 98, being facilitated by Admiral Howell and Mr. S. Sheikh. At this meeting would have a direct bearing on the SA Subclub. The meeting was requested to give Atlantis Consulting Pty Limited a mandate to negotiate depending on the direction of the meeting. It was agreed that should the SA Subclub be approached to include ADS, that ADS could be considered on the same grounds as other applicants. These conditions include that no founder member loses work share to ADS. ADS would become an associate member, and ADS agree on a quid pro quo with the SA Subclub with respect to work share should a French offer be accepted as prime contractor for the submarines.
What is the significance of the passages that you've just read with regard to what we're talking about?
Well, the significance involves conflict of interest. Now, I have to give the context. It's not an analysis of what this means, but it's the context. Although the SA Subclub, as I said before, was a grouping of companies involved in the entire spectrum of supply for the submarines, there was only one company at that stage, kind of a founder member being C squared R squared, that was involved in the combat suite, or specifically the combat management system, as we had an agreement, we had dealings with one of the submarine suppliers, being Fincantieri, but also we had various business negotiations going on with ST and Atlas regarding the involvement in the combat suite part of it. Now, of course, if I haven't been clear enough, ADS is also only involved in combat suites, combat management systems. So clearly, this issue involving a meeting with Mr. S. Sheikh is only about combat suites. And I do know that there was a lot of pressure. I fortunately don't have all the time I need. I could probably spend a day or two on the whole issue of the inclusion of a South African combat suite, and not only a South African one, but actually more of a French one, into the submarines, rather than the ones that the German had selected, the one from ST and Atlas. But I think this point suffices to say, or suffices to address at least a sub-theme of that of conflict of interest. Here we have somebody being the Chief of Acquisitions after he's been in the position of Chief of Acquisitions, knowing his brother's interest in Kobe Holdings and ADS and Thomson South Africa, getting involved in an issue where the conflict of interest is already at play, although it was only formally declared, as I've said before, on the 4th of December. The conflict of interest gets managed or handled once it becomes into play, not just when it's recorded. But anyway, here is a stark example of a situation where the Chief of Acquisitions got involved in the nitty-gritties of the combat suite for the submarine, which was being offered by the combination of Thomson and ADS.
Is there anything you wish to address through the minute of the next meeting, RMY 105, at our page 1932, or that deals with the same theme?
No, I think these are just further proof of this meeting having happened. It happened at the Chippy Sheikh's office. Maybe that Admiral Howell initiated or facilitated the meeting, but I don't think that is important in terms of conflict of interest.
Right, at your paragraph 501 and following, you deal with further meetings that Sheikh had with that company ADW, and so on. Would you like to deal with that?
Involved in this process, certainly at the earlier stages, we were quite deeply involved, especially because what became a controversy, either the German combat system or the French one, and so there was a lot of action going on here. I had meetings. I remember one particular meeting with Clement Steinkamp from HDW, actually in the Arms Corps offices in Simonstown, and I also remember many meetings with Peter Krollmann and Ernst Otto Max of STN Atlas. I remember actually after one of the meetings, it's actually more of I can say it was a presentation, or Chippy Sheikh called all the relevant parties of I think all the STPs. It wasn't just submarines, it wasn't just even naval systems, and Peter Krollmann and Otto Max were there. Of course, they are only involved in combat systems, and specifically combat management systems. And after that session in the Arms Corps building here in Pretoria, I met Peter Krollmann and Ernst Otto walking down the stairs as I was walking out a bit later, because I was catching a flight later. So that anyway, in that meantime, between the sort of presentation or whatever had ended, Chippy Sheikh had called Peter Krollmann and Ernst Otto Max to his office. And if I may say so, I didn't write this down, but they were as white as sheets. And these were very, very experienced campaigners in international bidding for combat management systems. And asked them why they looked like that, and they told me that they had just been read the Riot Act by Chippy Sheikh regarding their intransigence regarding the combat management system, and specifically with regard to ADS's inclusion thereof.
Did anything come of the proposals that were made for ADS to be included in this bid?
Yes, many things did actually come over it. In fact, I'm not going to testify about everything, but not just to let the point that but just to end completely sort of inconclusively, the whole effort to get the Thompson, I think they called it SABC. The actual name of the French combat system was called SABC, but the South African element involving ADS called the SABC. Now, I was intimately aware of all of this because we were going to develop parts of it, or at least parts of the software. But the DoD, Chippy Sheikh involved as well, insisted that this be considered. Eventually, somebody in the project team recruited somebody called Karel van der Merwe, ex-Navy officer, worked a lot on submarines, and he did an analysis. I think he spent quite some time in Germany. I don't know whether he spent any other time anywhere else, looking at the implications of the Germans for the very first time, including a French combat system, and eventually, this is after many months, several months, he issued a report, and based on risks and costs, the Germans prevailed. Of course, the German HGW in particular, and I know, were not happy at all to include a French combat system, or French combat system in a German submarine. In fact, the German 209 submarine is actually an export submarine. They don't even think the German Navy use it themselves, and they were particularly not enamored by this, because it would have be the first time that it would have happened, and that could have opened up the door for future submarines ordered from them by future clients, of not including a German combat management system and a combat system in general. So anyway, it was certainly a very big issue. But what I also do know from my personal involvement, because we were meant to get a contract from STN Atlas to do the torpedo fire control system, something that I'd worked on myself in earlier life, so I knew a bit about it. But I don't have all the details at my fingertips, but I believe a bone was thrown to ADS, is that STN Atlas would actually give ADS a small contract of something that reminds me about 10 million rand or so, to actually do the torpedo fire control system. Anyway, I don't think that actually happened at the end, but anyway, there were certainly, if I may say so, exceedingly strange maneuvers in terms of normal acquisition process of trying to force decisions at combat suite level and even subsystem level, at torpedo fire control level, on a prime contractor like the German Submarine Consortium.
And as you say, that did not happen. Would that be the conclusion of the part of your statement that deals with allegations of corruption with regard to submarines?
Yes, I think that's. I think I've said sufficient.
We will next traverse the allegations of corruption with regard to the jet trainer and the jet fighter aircraft. Perhaps we can do that when we come back from the lunch break. Would that be the convenient time to take the break, Chair?
Thank you. We'll adjourn for lunch, and let's come back at 2:15. Thank you.
Chair.